Well, we're 2 minutes past the hour, so let's get started. Hopefully more people can come in as we go along, but I've got a lot to cover today, so I better get going. First of all, welcome everybody. This is, as you know, an entirely informal discussion that we've kind of humorously called Bankruptcy from Henry VIII to Anna Nicole Smith. One caveat, though, I'm not going to get to Anna Nicole Smith today. So if she's who you came for, you might want to leave. But I will get there. Today, I'll probably only get as far as the Bankruptcy Act of 1898. In the second program in this series, I'll cover the origin of the separate bankruptcy clerk's office, closely aligned with the adoption of the Bankruptcy Code of 1978, and hopefully in that one we'll get also to the amendments of 2005 known as BAP Kappa or BAP Crappa, depending on who you talk to. And then in the third program we'll get to Anna Nicole Smith and her aftermath, if we can call it that, and possibly the future. So that's kind of the outline of where we're going. Second introductory caveat. Even though this program is informal and entirely voluntary, it is still subject to my rule number one that I always tell attorneys, and maybe you haven't heard it when I do programs like this, and that is no sucking up. Okay? Now, what that means is you shouldn't be here to suck up to me. You should be here because you think you're going to enjoy it. Now, with all rules, there's an exception. And the exception is here today, too. And here in the front row are my wife, Kathy, my judicial assistant, Pat Dink, my courtroom deputy, Janet Smith, my court reporter, Christina Johnson, my law clerk, Jim Yeager, and, of course, our clerk of court, George Prentice. Now, you should feel entirely free to suck up to them because they deserve it, all right? They're the people that keep me sufficiently organized and, frankly, encouraged, not only to do my day job, but also extracurricular activities like this. Now that brings me to another introductory comment about our larger purpose, and that is to provide the kind of justice to both creditors and debtors that the bankruptcy law is intended to provide. And that justice comes not just when the judge rules. That's just the culmination of a long process and a large team effort. Most of that team effort is the gathering, organizing, and recalling of an immense amount of data. Data consisting of names and claims and assets and dollar amounts. And that's the team effort most of you are involved with. And it's absolutely essential to the result. And I don't mean to trivialize this by resorting to a sports metaphor, which I usually abhor, but I think it's the only way to make it graphic. But if you think about it, the quarterback, the wide receivers, the running backs, even the field goal kicker would never be in a position to perform if the line of scrimmage isn't maintained. And that's got to be done play after play after play and day after day. And that's what you folks do. And nobody else could perform, and the end result could not be achieved without all of that work. And it truly is a team effort, because any failure by any team member can really mean the complete collapse of the entire project of providing justice to all the creditors and debtors. So I think you all already knew that, and in fact that's probably why you're here today, because you know this is a team effort and you're not here to suck up to some higher authority. But enough of the prefatory comments. Now let's have some fun. All right, first of all, who knows the origin of the term bankrupt? In terms of what language does it come from? How does it translate? Anybody? Close. Italian. Probably most authorities say Latin, and it's a combination of two words. Bancus, meaning bench. There's a bench back here, but it's not the one that it's referring to. And ruptus, meaning broken. So it literally translates to broken bench. What has that got to do with bankruptcy? Well, it refers to the situation where merchants did their job at open-air fairs or marketplaces, much like today's arts and crafts fairs, right? And they had a bench from which they sold their wares. Well, when a merchant failed to pay his suppliers, supposedly they would first, of course, clear out his merchandise and then break his bench to demonstrate to the public this guy's out of business, and the reason he's out of business is because he didn't pay his creditors. So that's the origin of the term broken bench. You might think that doesn't say a lot on today's theme, the history of bankruptcy, but it does kind of segue into one of the main themes of this whole history project, and that is, notice that what bankrupt originally referred to was a creditor's remedy. It did not refer to the debtor getting out of his obligations. It referred to a creditor's remedy. Also note that the remedy has some aspects. Very immediate, it's very practical, and it's probably just and appropriate for the circumstances. And I think all of those fit the bankruptcy remedy in general. So it's kind of a way to introduce the general theme. Generally, I'm going to be talking about Anglo-American bankruptcy law, but I should mention there are some predecessors. There are biblical references to debt forgiveness, such as the Jubilee every 50 years when all debts should be forgiven. There's a reference in Deuteronomy to creditors should forgive their debts every 7 years. I wonder, by the way, prior to BAP Kappa, you could only get a discharge every 7 years, and I wonder if that's why 7 was picked as that number instead of a nice round number like 5 or 10, because of the origin in Deuteronomy. But there were others. In ancient Greece, there was really no debt forgiveness. Anyone who owed debts he could not pay, they simply became a slave, along with his family, to the creditors for 5 years. In Rome, the debtor could be sold into slavery, and maybe you could sell the debtor for enough to get enough money to pay the debts, but in any event, the debtor's in slavery at that point. Or another remedy is he could be executed and the body cut up in the public square and literally divided among the creditors. This is the origin of the Shakespearean phrase, get your pound of flesh, because it supposedly was literary. You could get your pound of flesh. Not that it did you much good. All right, well, those are the pre-English. I'm going to start with English bankruptcy history, and I'm going to start with 1542, and here comes Henry VIII, because that's during the reign of Henry VIII. The title of the very first English bankruptcy statute kind of says it all, what it was intended to do. The title was An Act Against Such Persons as Do Make Bankrupt. An act against. So it was purely a creditor's remedy, and it was purely punitive. That's all it was. Punishment for dishonest debtors, primarily those who hid assets. Now, of course, the individual creditor's remedy, not a collective creditor's remedy, but an individual creditor, could have a debtor thrown in debtor's prison. And debtor's prisons were ubiquitous. You may be surprised to know that we had them in this country practically up until the time of the Civil War. They really were common. Certainly until the 1840s, they were common even in this country. That was a very common creditor's remedy. Senator Elizabeth Warren, who you probably all have heard from, she also was a Harvard professor and wrote the textbook I teach bankruptcy from. Kind of an interesting side note, her husband, named Bruce Mann, is a legal historian, and he wrote a book called A Republic of Debt. Or is it A Republic of Debtors? I know Ed Bernardovich is here and he's reading it, so...
Republic of Debtors.
Republic of Debtors. And it's basically the history of debtors' prisons. And they were almost incomprehensible. First of all, you didn't get put in debtor's prison for a term of years. It wasn't punishment in that sense. It's not punishment for a crime. You're just put in debt and in prison until you pay the debt. Well, there's some problems with that. Number one, if you had to work for a living, and that's how you made your money, was by working, not everybody does. But if you did, obviously you can't work for a living, so you can't pay your debt, so how long are you going to be in prison? Maybe forever. Secondly, even if you didn't work for a living, even if you were a speculator and you had assets, you know, that you had bought in the hope that they would increase in value, and that's how you always made your money, why would you turn them over to get out of debtor's prison when you're put there by one creditor if, as would ordinarily be the case, you don't have enough assets to pay all your creditors? Why would you? Because you turn them over to pay that creditor and get out of debtor's prison, and then some other creditor is going to come along and say, yeah, well, you didn't pay me, you're going back in debtor's prison. Only now you don't have any assets left. So, you know, I mean, these people, speculators, they're smart enough to figure that out the first time. So they don't even turn them over to the first guy. Unless there's enough to pay everybody, and if they were, they probably wouldn't be in debtor's prison. So what are they going to do? They're going to hold on to them. Hope the market turns. Hey, that's what speculators always do, right? You might as well hold, it's your only hope, because otherwise you're going to be right back in debtor's prison. So it was not an effective remedy to get people to turn over assets, even the portion that they had that could pay some debts. But the debtor's prison was even worse than that. At least in the United States, and I believe true in England as well, the idea was the state, the government, it did not have any responsibility to provide the people in debtor's prison with anything. Anything. They didn't have to feed them. They didn't have to provide them heat in the wintertime. They didn't have to provide them sanitation services. The debtor's family was expected to provide that, or charity, perhaps. And as one indication of how bad they were in this country when the yellow fever epidemic came through, and you know, it was primarily an event that occurred in the summertime, and some of the cities were evacuated because people had to get out in the country to get away from the yellow fever. They even evacuated the criminal prisons, but not the debtors' prisons. So they were pretty bad stuff. All right. In any event, that was all just kind of background to this first sort of collective creditors remedy, which again was purely punitive, primarily for dishonest debtors. A second statute was passed in 1571. Now we're in the reign of Queen Elizabeth. It was essentially the same as 1542, purely punishment for dishonest debtors, purely what we would call today involuntary bankruptcy. What's an involuntary bankruptcy? It's when it's a bankruptcy filed by the creditors rather than filed voluntarily by the debtor. We don't see many, but we still have them, and that's what we call them today. These bankruptcies were only involuntary. Well, of course, the debtor wouldn't want one. He had nothing to get for it. But in any event, they were purely involuntary, and they were limited to merchants and traders. Only a merchant or a trader could be subject to an involuntary bankruptcy. A brief side note about 1571, which happens to be the 13th year of Queen Elizabeth's reign, and that year is also the year then that gives rise to what got known as the Statute of 13 Elizabeth. That statute is the origin of our fraudulent transfer laws. It's a side note to today's topic, however, because it was not part of the bankruptcy statute passed the same year. It was really a taxing remedy. It was a way to increase the ability of the Crown to collect taxes from the noblemen that owed them. These are feudal taxes. It doesn't really become a general creditor's remedy until Lord Coke reports Twine's case in 1601. And it's his report of that decision that morphs this taxing statute into a general creditor's remedy to recover fraudulent transfers, property that a debtor has fraudulently transferred to hide it from creditors. That's the topic of another course. I don't know if we'll get to it in this series or not, but I'm just mentioning it as a side note that it's somewhat interesting that although today we think of it as a bankruptcy remedy, it didn't start out that way, and it wasn't even part of a bankruptcy statute that happened to be passed that same year. Now, there were other bankruptcy statutes passed. They were all generally on the same pattern, so I'm not even going to mention them. 1604, 1623, 1662. The next one I'm going to mention, though, is the one that gives rise to the remedy of the discharge. Obviously, as I've already mentioned, putting someone in debtor's prison was not very effective, even for creditors. It just didn't work, and it was inherently ineffective. I gave you as a handout, and I hope you all got it, a little essay, and this is just a short excerpt of a much larger essay written by Daniel Defoe in 1697, in which he's arguing why we need to change this law, why it doesn't work, why it's wrong-headed in a number of respects. And I think his dividing up to there are two kinds of debtors and there are two kinds of creditors. And the problem is finding a law that is just and just in its treatment in all four of those categories is absolutely accurate today. Now, effectively, what he's already doing here is saying this law, imprisonment for debt, doesn't work. Now, he also says it's inhumane, but the primary thrust of it is for creditors, it doesn't work. So now, second trivia question of the day. Who was Daniel Defoe? An author. What did he write? Robinson Crusoe. He was already famous by this time. Robinson Crusoe had already been published, and so he was already a famous person in England. So he had some basis from which to lobby. I mean, people listened to him. If you note, if you read through this, and probably haven't had an opportunity to do it yet, maybe take it with you, but he talks in here about his experience as a creditor. Well, like many authors, he also had experience being a debtor. Like, for example, our own Mark Twain. I don't know, another trivia point, if any of you know. He went through bankruptcy. Well, Daniel Defoe had experience, first-hand experience with being a debtor in debtor's prison. So he was speaking from some personal knowledge. Well, then what happened? So he's lobbying as early, if you want to call it that, as 1697. But what ultimately happened, like often happens in our country, things don't get done just because they'd make sense to do. I mean, it's government we're talking about after all. It takes some crisis to bring something to a head, and that was the Pitkin Affair of 1704. This was a bust-out scheme, and for those of you who don't know it, I'll explain what a bust-out scheme is. But first, the big picture. It was a bust-out scheme in which two conspirators had a very elaborate plot and implemented it, and in the course of 9 months, they absconded with £50,000. Now, in today's money, that would be about $150 million. So it was a scheme in which in 9 months, they raised and ran off with $150 million. And they did it from the prominent tradespeople and lenders and bankers in London. So you can imagine they were pissed. And it certainly had the magnitude of the Bernie Madoff scheme. All right, what's a bust-out scheme? A bust-out scheme is where the first step of it is you create the illusion that you are wealthy and creditworthy. And you got to work some to create that illusion, especially if you're not wealthy and creditworthy. But you can do that with some careful planning. Raise some credit. In their case, they were dealing in wool, but it doesn't really matter what they were dealing in. So they bought wool, resold it, repaid the creditors, got a big business going there. Ultimately, they get a whole lot of credit because they're treating their creditors well, they're paying them back, they look highly successful. And then when you want to bust out, what you do is just sell all the wool, convert it to money, and abscond. As I said, this was a plan between two conspirators, Brailsford and Pitkin. Brailsford was entirely in the background in the first two phases of this whole scheme. And then Pitkin's the guy that takes all the money when they sell all the wool and don't pay back the creditors and absconds with the money. And the plan was he'd leave on a boat in the middle of the night and eventually make his way to Italy, I think, where they thought he would be exempt from any process in England. Now, the scheme was that after he did that, and of course all the creditors then are up in arms and find out we're not getting paid, and we can't find any wool, and we can't find any money, Brailsford surfaces, even though, of course, he was in on this from the beginning. And he says, you know, I think we can at least salvage something out of this. I'll buy all your debts for 25 cents on the dollar. And the creditors now realizing they're not going to get anything because Pitkin's gone, the money's gone, the wool's gone. Okay, we'll take that deal. And so Brailsford's able to pay them 25 cents on the dollar for their debt. After that, because the debts are now gone, Pitkin come back from Italy where he's been hiding out, and the two of them can share the proceeds, and they're totally exempt from any process or action by their creditors. So that was the plan, and it was the plan from the get-go. It was a pretty sophisticated plan, and they did a darn good job of implementing it. Only at the last minute they tripped up, and it was found out that he was absconding on the boat, and he was tracked down, and he was arrested in Italy, and Italy decided, yeah, maybe out of a sense of comedy, we'll hold this guy for English authorities to show up, even though there was no treaty under which they could do that. But in any event, the scheme collapses. But still, the creditors, they couldn't find the wool or the money. I mean, just like Bernie Madoff, right? Where'd all that money go? Nobody knows. Even today on this scheme, nobody knows where it all went. But the creditors were not finding much, even though they've got Pitkin. So they go to Parliament for a remedy. You can imagine what it is. Well, first thing we want to do is punish Pitkin. So they get a bill passed that was directed solely at Pitkin. I mean, and they could do that in those days, right? Providing for his punishment because they concluded the existing remedies under bankruptcy law were not harsh enough. So which were, the existing remedies at the time was you would stand in the pillory for 1 hour, have your ear nailed to the pillory, and then cut off. Okay, they decided that was not harsh enough for Pitkin. So they drafted, and Parliament passed, and this is before he'd actually been extradited from Italy, a law saying that if he did not surrender all of his books and papers and assets, but the books and papers were keys. Where did the wool go? Where did the money go? So they could start tracking it. If he didn't surrender all of that and return to England, then he would be sentenced to life imprisonment and stand in the pillory 3 times per year for the rest of his life. So that bill passed. The same day, though, Parliament started thinking, well, you know what? Our bankruptcy laws in general aren't effective enough. So they immediately at the same time started considering a general reform to what would have been, in effect, the equivalent of the Act of 1571. We need to upgrade the remedies in bankruptcy. Now, that bill doesn't get passed, even though they started debating it literally the same day they passed the Pitkin bill. It doesn't get passed for a year. And during that time, Daniel Defoe resurfaces, and he lobbies very heavily because he's very interested in this kind of bankruptcy reform. And so when the bill ultimately gets passed, about a year later, it has 2 new provisions in it. Number 1, it has capital punishment. They actually, the parliamentarians, the House of Lords, actually had added that to that bill the day they first started considering it after passing the Pitkin bill. Okay, the punishment for a dishonest debtor is going to be life imprisonment, not just stand in the pillory and have your ear cut off. It's going to be capital punishment for a dishonest debtor. But largely as a result of Defoe's lobbying, they also included a second issue, and that is the discharge. An honest debtor could get out of his debts. So in effect, and Defoe was lobbying for this not out of humanitarian reasons for poor debtors rotting in debtors' prisons, he was working to make the remedy more effective. So even the discharge was added as a creditor's remedy. And again, remember, this, we haven't changed anything else here, so this is still involuntary bankruptcy only. Creditors can bring it against debtors. And it's still limited to merchants and traders. But the idea was, let's add a carrot. Let's add a reward, because we've already found out that if we just put people in debtors' prison, they don't have any incentive to disclose their assets and turn them over or testify truthfully about where they are. So now let's create that incentive. And the incentive is, if you do that, you can get a discharge of all of your debts. Now, it wasn't automatic. The creditors would elect commissioners, and the commissioners ultimately would decide whether the debtor had been honest or not. Ever wonder why we have our first meeting of creditors? Any of you ever think, where's the second meeting? Well, duh. I mean, if we're going to have a first meeting, aren't we going to have a second one? Why is it called the first meeting of creditors? When do we ever have a second meeting? I've never known to have a second meeting of creditors. Well, you did under this, which becomes known as the Statute of Anne, because Anne is the queen at the time. The Statute of Anne had 3 meetings of creditors. So at the first one, you interrogate the debtor. Where are your assets? Where did you spend all the money? How did you possibly blow all that money? All of those kinds of questions, okay? Second meeting of creditors, the creditors get a report on, well, what have the assignees, as they were called at that time, find based on what the debtor testified to? Were you able to find these assets and recover them? And how much are you going to be able to liquidate them for? So how much are you going to collect to turn over to us? And then at the third meeting of creditors, they vote. Well, does he get a discharge? Was he honest? Or does he get the death penalty? Well, you may see why we don't have a third meeting of creditors these days. You can also see why this bankruptcy was still purely involuntary. I don't think any debtor would say, I want to voluntarily subject myself to a vote of my creditors of whether I should get a discharge or the death penalty, even if I think I've been completely honest with them. So it was a creditor's remedy. That was the state of the law then, but that was the invention of the whole idea of the discharge. And by the way, did you ever think of why it's called a discharge? I mean, that isn't what we usually refer to what you do to a debt when it is somehow satisfied or gone away, right? I mean, what do you do to debts? You satisfy them? You release them? You ever discharge them? No, that isn't what the discharge primarily meant. It primarily meant the debtor got discharged from jail. That's what the discharge meant. Now, it comes out later in our history, by the way, that really means there are two kinds of meanings of discharge, because you could possibly get a discharge from jail, but not a discharge from debt, which would mean that maybe you could get thrown back in jail. You know, you got out this time, you got to get out of jail free car on these debts, but then some other creditor could throw you back in. But in any event, that's why it's the discharge, because the primary concept is the debtor gets out of jail. All right, well, that was the statute of Anne and the way the discharge worked, and that was purely the model that existed. I put down 1752 because that was the next bankruptcy statute in England. No significant difference. Still involuntary only, limited to merchants and creditors, merchants and traders. Included the discharge, but it wasn't automatic. It was voted on. One reason I put 1752 up here, though, even though it's no change from 1705, is because this is the statute of bankruptcy that was in effect in England when the United States was formed, right? So if, in 1776 or 1789, anybody talked about bankruptcy, what did they think bankruptcy meant? This or this. That was the model, and the only model that we had. Well, remember, we had states before we had the Constitution. Not colonies, but states before the Constitution. Anybody? Here's another trivia question. Although this isn't so trivial, you should remember this from high school history. Why did we have states before the Constitution was adopted? Remember, the Constitution wasn't adopted until 1789. Wasn't proposed until 1787. Well, we became independent and were no longer colonies in 1776. So what happened in the intervening 13 years? Anybody remember their high school civics? Articles of Confederation. Remember that? We had states, but their organization was largely voluntary. The federal government was just a confederation of states and had no ability to collect taxes, raise an army. It was relying on the states voluntarily to provide all that, and of course it didn't work. That's why we had to propose a constitution. But for 13 years we had states, and the Constitution wasn't in effect. Now, during that time, many of those states then, they were the ultimate authority. Some of them adopted their own bankruptcy laws. Or they didn't. Or they dealt with it on a case-by-case basis. Maybe if you've got big problems with debt, but you're well-connected, think of Fife-Symington. What you did is you went to your legislature and say, pass a bill that releases me from my debts. And if you got enough political clout, you could get that done. Or pass a bill that lets me out of jail if you're in debtor's prison, right? And maybe the well-connected could get that done. Other states had some kind of bankruptcy law that may have provided for a discharge on this model. The problem with all of those laws was, even the ones that were well drafted on this model, is that no state could grant you a discharge from debtor's prison in another state. Or could they discharge you from a debt owed to a creditor in another state. We didn't have an effective full faith and credit clause in the Articles of Confederation. But even if we did, it really would be debatable whether any state's discharge order would have any effect in another state. When it came time to the Constitutional Convention, some of the lawyers who were there, this was their practice of trying to enforce. First, they got a discharge for their client, but their client, he was a nationwide trader or merchant or speculator. So he owed creditors in many different states. And so now they had the problem. If he ever wanted to leave his home state and get back into business, he needed to make that discharge effective in another state. And some of the delegates at the Constitutional Convention were well aware of that problem and knew that it was probably insoluble. Consequently, at the Constitutional Convention, it was proposed, let's authorize Congress to create a uniform federal bankruptcy law. And in your handout, you've got what gets adopted. Note that it's not a requirement, and it's certainly not an individual right. This appears in the Constitution under the grant of enumerated powers. One of the enumerated powers of Congress is to pass, if it wants to, an uniform law on the subject of bankruptcies, and in the same clause, an uniform law on naturalization, if it wanted to. So that was proposed at the Constitutional Convention. There was really only one objection to it raised at the convention, and that was Roger Sherman of Connecticut. And his objection was, we don't want a death penalty here. And this is going to be authorizing Congress to propose a bankruptcy law. And you know what? From everything we know, bankruptcy law includes the death penalty. That was his objection. Of course, it doesn't require Congress to pass that kind of a law. So it gets adopted, and Congress, surprisingly, I think, immediately takes up the subject of a bankruptcy law. Right away, 1789. The whole government has just been created. They got a lot of work to do. If you think of it, we didn't even have a court system yet. I mean, what did we have? We had Article 3 of the Constitution. There shall be one Supreme Court, and such inferior court, that's us, as Congress may from time to time decide to create. Well, we didn't have a court system created in the Constitution, so one of the very first things this Congress had to do was to create a whole court system. And they did, the Judiciary Act of 1789. They did it right away. But it's kind of surprising that among all of those first high priority items of a brand new government, they did take up a bankruptcy bill. Now, it didn't pass. And they continued to debate it, much like Congress today. It didn't pass until 1800. By the way, obviously he wasn't Chief Justice John Marshall at the time, but John Marshall was on the committee that drafted the bill of 1800. So he knew how this bankruptcy law was intended to operate. The Bankruptcy Act of 1800 is virtually identical, probably even more than virtually, in most cases literally identical to the British Act of 1752, even to including their drafting errors. I mean, saying things like, you know, either a man or a woman can file bankruptcy. What are your exempt property? Well, your exempt property is your clothes and your wife's clothes. Wait a minute, what if the woman's the one that filed? I mean, so those kind of sort of drafting glitches that were there in the English one, they're in our Act of 1800. But otherwise it's identical, except, guess what? No death penalty for dishonest debtors. That simply wasn't there. But the discharge was. Now it still gets voted on. But now a debtor doesn't have the downside of that vote. Now it's also like the Act of 1752 and the other major respects. It's only involuntary, it's only a creditor's remedy, it's only for merchants and traders. But even then they had clever lawyers. And some of them figured out that people who are in financial problem, they now may want this bankruptcy. So the first thing clever lawyers did is advise these debtors, go find a friendly creditor who can put you into bankruptcy so that you can get the discharge. Yeah, but I'm not a merchant and trader. I just, dabbled in the stock market and got wiped out. I'm not a merchant or trader. Some lawyers even advertised, no problem. Go buy some bales of hay and then sell them to your neighbor. Now you're a merchant. Okay. And they literally did it. So even though it was an involuntary remedy, you actually found debtors working to, in effect, file their own voluntary through a friendly creditor. Why was it passed? Well, there was a financial collapse, as you might guess, after the Revolutionary War. You can imagine what a huge financial disaster that was for the country in two respects, at least two respects. First of all, wars, of course, are very expensive. But secondly, our major trading partner was who? England. So our economy was cut off. All trade with England ended during the Revolutionary War. You can imagine what that did to the economy. So there was huge economic collapse. You all know, of course, how Washington's army suffered in the field because they couldn't get clothes and food and so forth. One of the he was called the financier of the Revolution, was Robert Morris. Very wealthy, primarily from land speculation. Was known for contributing much of his personal fortune to feed and clothe Washington's army. Well, we all know what happens to speculators, right? Especially when there's an economic collapse. So he wound up in debtor's prison. And he actually was in debtor's prison for 3 years, and he gets out under the Act of 1800. He gets a discharge. So here's another trivia question. This was a huge economic collapse. What do we call the biggest kind of economic collapse you can imagine? What's the term for it? The word we don't want to use anymore. I heard it over. The Depression. Wrong. At least not in these days. In these days, a financial collapse was called a panic. And every one of them, up until the Great Depression, was called a panic. And so you had the panic of, in this case, two of them, 1792 and the panic of 1797. Huge economic collapses. How do we get to a depression then, which we tend to think of as bigger than any other? Well, that was political spin by the Hoover administration. Don't worry, we're not in a panic. This is just a depression. We're all just a little depressed now, but don't panic. Well, this political spin was effective. He got the term adopted. But of course, it got the different meaning. So now, that's what we use for the worst kind of economic collapse. But in any event, up until then, they were all panic. The term we don't really use anymore. But if you read history, that's what all of these were. And every bankruptcy law that gets passed until the Bankruptcy Code of 1978, gets passed in response to and after a panic. And that has some significance. The Act of 1800, as I say, it took a long time for Congress to adopt it, and one of the reasons was, even though we had the panic of 1792 and 1797, was major opposition from the Southern agrarian interests. And part of the reason is, at least in that time, farmers were always in debt. Thomas Jefferson was always in debt. One reason, particularly if you're a tobacco farmer, is you couldn't get money for your tobacco crop until 18 months because you had to raise it, harvest it, and then dry it. So you don't get money for your crop for 18 months from planting. Only trouble is that 1 year, you need to plant your next crop. You need to finance your next crop. You don't have money from the last crop yet. How are you going to do it? You borrow. Well, no problem, because, that last year's crop is going to satisfy your financing of the next crop. Well, that works as long as tobacco prices are rising. They never rose. Tobacco prices always fell. So every year, a tobacco farmer has to borrow more money than he's going to get from last year's crop. The Southern agrarian interest opposed bankruptcy relief then primarily because they didn't want Northern creditors to take their farms. And that's also coupled with the fact that many of the states protected them. So, for example, in Virginia, it wasn't really a homestead. A creditor could not take land, period. You could not execute on anybody's land to satisfy a debt. You couldn't take a farmer's land. Well, Jefferson's concern was, if we pass a bankruptcy law, though, and it's federal, well, that land's going to become property of the estate, and effectively we've created a way for these Northern creditors to foreclose on our land and take our land away, even though you couldn't do that under Virginia law. And that's why there was a lot of opposition to the passage of this law. That becomes significant years later, and really throughout our history. But we'll come back to that. Well, the Statute of Anne, enacted in response to a financial panic, was really to deal with that, and therefore it had built into it a sunset clause, what we would today call a sunset clause. So it was intended to last only 5 years, and in fact, it got repealed after 3. So now, by 1803, there is no federal bankruptcy law. And as you can see from the list, you probably already figured out what these numbers are. We don't have one until 1841. So, what happens in the meantime? Well, we're back to states. They can enact their own laws. And one of the first constitutional decisions on bankruptcy was by Chief Justice John Marshall. I think it's Sturgis v. Crown and Shield, in which he holds that states can enact bankruptcy laws so long as there is no federal bankruptcy law in force. If there's a federal bankruptcy law in force, states can't touch the topic. But if there is no federal law, yeah, you can pass your own. One huge exception. On your handout, look at the other constitutional provision that I gave you. It was put into the Constitution that no state may impair the obligation of contracts. Well, if you pass a law that says you can get out from under the creditor's principal remedy, which is still debtor's prison, do you think that impairs that creditor's contract? Yeah, it does. That's exactly what it's intended to do. We're taking away your remedy. So, the other thing that Sturgis v. Crowninshield held was that a state cannot pass a bankruptcy law that discharges any debtor from a debt that was incurred before that law was passed, because that would impair the contracts of the parties that entered into that when there was no bankruptcy law in effect. And that was pretty much saying you can't pass effective bankruptcy laws because if you think, as had always been the model, well, we pass them in response to a financial panic, we're passing them in response to debts that were previously incurred, not we're planning for the future. So effectively, states cannot adopt effective bankruptcy laws even in the interregnum when there is no federal bankruptcy law. All right, the Act of 1841 is the next one then. That gets passed in response to the Panic of 1837. The major difference now, and you can kind of guess how this law evolved based on what happened under the Act of 1800, it's now also voluntary. Let's forget this hokum of having you find a friendly creditor to put you in. You can file on your own. You can file voluntary if you want. It was not popular, nor probably effective. It was repealed in less than a year. So I'm not going to say a whole lot more about it, except that unlike what we're used to today, it also did not preserve state exemptions. All right, the next act of 1867, you can imagine what that was passed in response to. Civil War. You think the Civil War caused an economic collapse? Boy, it sure did, for a number of reasons. One of them was that one of the first acts of secession was the southern states repudiated all the debts that they owed to the northerners. And by and large, that's the way the economy was worked. The lenders and stuff were in the north. Of course, also still in England. But, so yeah, the Civil War was a huge economic collapse. Take a look at how long it took Congress, though, to adopt a bankruptcy act to deal with it. They finally got around to it. It was debated for 5 years. Now, it's not only a voluntary bankruptcy, but it also is not limited to merchants and traders. It now includes all moneyed business or commercial corporations. Another key aspect, though, is that the involuntary bankruptcy was not limited to merchants, but could also be filed against farmers. So now, just what Thomas Jefferson feared is happening. Of course, the North has all the power. And of course, the other odd historical thing, I've never figured this out, the northern states that had control of Congress would actually negotiate from a real point of leverage to a state. They'd say, in effect, we're not going to let you back in until you agree to relief that we want like this. Wait a minute, I thought the whole theory of the Civil War is you can't secede and you never did secede. Only now Congress is saying, well, we're not letting you back in. Nonetheless, that's what they did. So again, it was debated for 5 years, primarily due to opposition from the southern and the western states. One compromise that was struck in that negotiation, though, was, and we're familiar with it today, each state can define its own exemptions. So now, to respond to the southern states' concerns about taking the farmers' property away, you, if you want, can say a farmer's homestead or farm is exempt. And if you do that in your state, it'll also be exempt under this federal law. A huge compromise. Another big difference of the Act of 1867 was that for the first time, it was intended to be permanent. It did not include a sunset provision. So this is the first time Congress ever thought we need a permanent bankruptcy law, not just one that's sporadically adopted in response to a panic. We always need a bankruptcy law. Well, they were right and wrong. They were probably right that we needed it, but it nonetheless gets repealed after a dozen years or so. So although it was intended to be permanent, it got repealed. Repealed in 1878. And one of the big problems with it, at least perceived problems, that led to its repeal was the ability to file an involuntary against a farmer. Because you see what that does. He has one bad crop here, and he loses the farm. Because he can be put into bankruptcy and we sell the farm. And so that was perceived to be one of the big problems with it. So the next time we have a bankruptcy law is the Bankruptcy Act of 1898. And to anybody that knows anything about bankruptcy, this is what's known as the Act. And the Act is distinct from the Code. The Bankruptcy Code of 1978 is the Code. The Act of 1898, that's the Act. It was intended to be permanent and was. We have always had federal bankruptcy law since 1898. It was first introduced in 1890. This time it's debated for 8 years. We also had the Panic of 1893 during that process. We also had the collapse of speculation in Western land that occurred in 1887 to 89. The bubble, the housing bubble we went through, and Ron Denk probably knows this well, bubbles are not new. We've always had bubbles. It's what the bubble occurs in that varies from time to time. I mean, in one time in the 1400s, the bubble was in Dutch daffodil bulbs. I'm not kidding. But you can have a bubble in anything, and we've always had them. Well, we had one in Western land. By the way, one of the big bubbles in this time right here was in land in Washington, D.C. If you think about it, we adopted a constitution that says Congress is going to establish a national capital, and we're going to carve it out of land, and we're going to take it from somewhere around Maryland, Virginia. Oh, do you think people bought up that land? Boy, they did. A lot of speculation. And like a lot of the recent bubbles, too, it wasn't just the speculators. They went around and raised money from ordinary people to buy into the bubble. You know, you lend me money so that I can buy land and I'll share the proceeds with you, that kind of thing. That's been with us forever, too. So it was intended to be permanent. It was both voluntary and involuntary, as the Act of 1867 had been. But now one big change. No involuntary can be filed against a farmer. And that's still the law today. That was retained in the Bankruptcy Code. That huge compromise was reached. You cannot involuntarily put a farmer into bankruptcy. The other compromise was retained too, and that is individual states' exemptions were retained. Each state can define its own exemptions. It included both individuals and corporations and partnerships. But what becomes key, and I'll run over a little bit here, what's not in this statute is any reorganization. Like all of these bankruptcy statutes, it's purely liquidation. You do not reorganize under this law, but you can liquidate. Now, of course, a corporation doesn't need a discharge. Certainly doesn't need a discharge from jail, right? And they don't even need a discharge from debt, because you can just dissolve a corporation. You can't, dissolve a human being, except the Wicked Witch of the West, I guess. But so they don't need a discharge. But nonetheless, it was a collective creditor's remedy to collect the assets of the corporation and distributed them pro rata among creditors. So corporations could file, but bankruptcy at that time meant liquidation. It's what later becomes called straight bankruptcy. How do you reorganize a corporation? How do you reorganize a corporation when we don't have a statute for it? Well, we certainly had a need to reorganize corporations, primarily railroads. From the late 1800s to the early 1900s, huge corporations with a lot of public debt and public equity, maybe layers and layers of it, different bond issuances, different stock issuances, much of that financed in Europe. Some of it, by our own J.P. Morgan types, but a lot of the European financiers were investing in these railroads. And as more modern history tells us a lot of railroads fail. And they need to reorganize, right? Because how are you going to get any value out of a failed railroad? Rip up the track that got laid and melt it down and sell it for scrap? You're not going to get much that way. You're going to get a lot more value if you can finish the track and start running the railroad. But it's already got too much debt, so you got to get rid of that debt before anybody's going to invest any more money into finishing it, even though everybody recognizes that there's a lot more for everybody if we can do that, if we can finish it. So you need a way to strip off debt so that new people can invest new money. How are you going to do that? No statute to do it. Once again, clever lawyers to the rescue. They invented a means with no statute. What they did is they said, well, a lot of this debt are bondholders. What's a bond? That's an ambiguous term in the law. There are many different kinds of bonds. And I'm not talking about bail bonds, okay? This kind of a bond is a secured debt. Usually a bond is called a bond because it's sold widely. So you got thousands of investors that have a pro rata interest in the same debt and the same collateral. So it's secured by the assets. It's a secured debt, but with many investors in the secured debt. Well, bonds are secured debt. They can foreclose. So one thing you do is you start the foreclosure process. Well, obviously that's not going to reorganize the entity, right? I mean, that's just going to liquidate the assets and send it off to the creditors who are foreclosing. But of course, how does a foreclosure work? You actually go to sale, right? How are you going to sell a failed railroad? Who's going to pay anything for it? So the same people that set up the foreclosure said, here's what we're going to do. We're going to create a new separate entity, a shell corporation starting out. And here's what it's going to do. It's going to offer you, bondholder, the ability to sell us your bond. Just your bond. Maybe worthless today. But you give us your bond. In exchange, you'll become a stockholder of the new corporation. Then what is this new corporation going to do? It's going to take all the bonds that it got that way, and it's going to credit bid them at the foreclosure auction. So utilizing those bonds, it's going to become the owner of the railroad. And who are going to be the stockholders of this new corporation? The old bondholders who agreed to contribute their bonds. So now we have stripped off a whole lot of debt. All of the junior secured debt, it's been foreclosed out, and certainly all of the unsecured debt is gone. So now we've got an entity that people can invest in, knowing that there's some value in what they're investing in, because we got rid of all of this debt. Well, who's going to do this? Who's going to run the railroad in the meantime? And where are you going to get any new money? Because you haven't gotten any money yet, right? You just got these worthless pieces of paper called bonds, and now you own a failed railroad. So where are you going to get the money that you need to finish the job? Well, one way is you offer a deal to the old stockholders who are being wiped out. You tell them, you know, you want to save something out of your failed investment? You can become a stockholder in the new company. Only your deal's not going to be the same as bondholders. They only have to give us their bonds. Old stockholders, you got to give us your old stock and some money. So, for every share of old stock, you give us $10, and we'll give you a new share of stock in the new company. Well, now what have we got? We've got some money. More importantly, the old stockholders were effectively old management. They're the ones that know how to build a railroad, theoretically. Failed first time around, but... So, in reality, they may be the ones that put this whole deal together to keep themselves in control. So that's how you raise the new money to finish the railroad. By the way, you also need new money for something else, and that is all the old bondholders who said, no, I'm not giving you my bond. Well, they've got to be bought out in the foreclosure sale too. They got to get their pro rata share of the credit bid. And the only way you can get it to them is to give them cash. So you got to raise the cash to buy out the dissenting bondholders. So that's the way reorganizations were done when there was no corporate statute, no statute for corporate reorganization. Now, problem is that in a number of Supreme Court cases, Railroad Company versus Howard, 1869, Louisville Trust, 1899, Northern Pacific Railway versus Boyd, 1913. 3 times the Supreme Court said, you can't do this. Get it? You can't do it. Why can't you do it? Because the old stockholders are becoming the new stockholders. What's happened to the old creditors? The old unsecured creditors? Their debt's wiped out. Wait a minute. Creditors always have priority over stockholders. That's fundamental corporate law. If there's any value in this thing, it first has to go to creditors before old stockholders. And yet you've come up with a scheme where the old stockholders get something out of the deal and the old creditors get nothing. That's not fair. So particularly Boyd adopted a rule of at least creditor priority, and it said you can't do this. You cannot allow the participation of old stockholders unless the old creditors are given a fair offer. They've got to be given something. Now, Boyd itself did not decide what that is. That gave rise to 2 theories of what it is. They could be given something that maintained their relative priority over stockholders. So, for example, here's the deal. Old creditors, you get priority stock, and old stockholders, you get common stock. So now we've maintained the relative priority between old creditors and stockholders because the old creditors have a higher priority on liquidation than the new stockholders. Their relative priority is maintained. The other theory is, no, you can't do it at all unless the old creditors are paid in full, in cash, maybe over time, maybe with stock that'll ultimately convert into cash, but they got to be paid in full. Well, as we'll see, that's the decision Justice Douglas makes within literally 6 months of becoming a Supreme Court justice, coming from, significantly, being the commissioner of the SEC. But this is far forward. Now we're talking 1939. Before we get there, let's talk about a couple other things, and I'll need to let you go in about 5 minutes. Obviously, the Great Depression caused a need for corporate reorganization. The first response that Congress came up with, of course, led by FDR, was the Fraser-Lemke Act. And it was pretty simple. It was just a moratorium on farm foreclosures. Let's just stop everything for a while. Quit taking the farmer's property. We got a moratorium, okay, till we figure our way out of this thing. Supreme Court says, unconstitutional. Why? Taking of property in violation of the Fifth Amendment. You took property without just compensation. Whose property did you take? The secured creditors. His mortgage rights. You took away the rights he had under the mortgage on the farm. Unconstitutional. Well, Congress came right back and passed the second Fraser-Lemke Act. Okay, another trivia question. What is the switch in time that saved 9? Anybody remember that one? You ever heard the phrase? No, this is the switch. It's a trade-off on the standard. This is the switch in time, not the stitch, the switch in time that saved 9. Well, in response to the Supreme Court constantly finding his acts unconstitutional, FDR came up with the court packing plan. I'm going to put a new justice on the court for everyone that's over 65. Of course, you could do the math. That would give him enough justices that he could appoint that would override the existing majority of the justices. It wasn't very popular, even in Congress. But Congress never ultimately got to vote on it, because when the second Fraser-Lemke Act came up before the Supreme Court, one justice changed his vote. It was held constitutional. Why isn't it a taking of the secured creditor's property? It's just a moratorium. We just delayed your rights. We didn't take them away. It's just a delay. That's not an unconstitutional taking. Now, frankly, the switch in time is usually referred to another act, the Reconstruction Act, I think. But actually, there were about 5 decisions that came down the same day. And in all 5 of them, suddenly, what the court had been routinely declaring unconstitutional gets upheld. That's the switch in time that saves 9, i.e. it saves the 9 jobs, and why we still have a 9-member court. End of court packing plan. And the Bankruptcy Act of 1898. So this is the first response to the Depression, but we need a reorganization statute. Well, now we've got a way to do it. So ultimately, Congress passes what get called the Chandler Act amendments. And this is what made the Bankruptcy Act, you might say, modern. The Bankruptcy Act we all came to know and love, at least us old geezers who had something to do with it. Because what the Chandler Act did was add to the existing Bankruptcy Act of 1898. Didn't repeal it. It just added to it. And what did it add? It added chapters. You ever wonder why they're called things like Chapter 11? It's because the Chandler Act added chapters. And here's what it did. Under the original Bankruptcy Act, bankruptcy was in a Chapter 7. Key trivia, by the way. Under the Bankruptcy Act, all chapters were in Roman numerals. Big change under the Bankruptcy Code. We go to Arabic numerals. All right. The Chandler Act then starts adding chapters. And here's what it adds. Chapter 9. Functionally equivalent to today's Chapter 9, like Detroit is in and San Bernardino. Municipal bankruptcy. It added 2 corporate reorganization statutes, 10 and 11. They are functionally equivalent to today's 11, and we'll talk about what the Bankruptcy Code did to merge these 2. It added a Chapter 13, before it added Chapter 12. Not akin to today's Chapter 12. This was for real property reorganizations. Many say it was special interest legislation to save some real estate investments in the Chicago area. Very specific legislation. Today's Chapter 12 is for family farmers. But it did add a Chapter 13, a wage earner plan. Very similar to today's Chapter 13. So now, for the first time, we get a corporate reorganization in Chapters 10 and 11. And with that, since it is now past 1:15, I think to end today's lecture, and we'll pick up there next time.